Torkonoo. She has launched a scathing attack on the presidential committee, probing her removal, accusing it of subjecting her to mental torture, degrading treatment, and systematic violation of her constitutional rights. In a fiery supplementary affidavit filed at the Supreme Court, the Chief Justice, which was done on the 26th of May, she painted a grim picture of an inquiry she claims is designed to humiliate her and force her out of office unjustly. Justice Torkonoo's affidavit contains specific details and a litany of grievances, including one, the denial of basic rights. Now, she and her lawyers say that they were barred from using their phones or laptops during the hearing, while petitioners' counsel retained full access, a move she calls deliberate discrimination. Invasion of search. She also indicated that she underwent body searches and was denied family support, with her husband and children refused entry to the hearing room. She had complaints about the venue of the hearing, which is the Osu Castle. Now, she says hearings were held at the Osu Castle, a high security zone, unlike past Article 146 proceedings, which were conducted at the Court of Appeal, at the courts complex. She questions the intimidating choice of location and also raised the issue of procedural irregularities, and says petitioners were allowed to avoid testifying in person, relying instead on witnesses, a departure from standard inquiry rules requiring cross-examination under oath. So those are the key issues raised by the suspended Chief Justice, Her Ladyship Gertrude Torkonoo. Now, the Attorney General also says, in a response to what Madam Chief Justice has been saying, the Attorney General has responded and says, in-camera hearing is a constitutional command geared at safeguarding not only the Chief Justice, but the entire judiciary. It can therefore not be waived. This comes on the back of the Chief Justice asking that her hearing should be made public and not in camera, but the Attorney General thinks otherwise and has responded accordingly. Also, the Attorney General says there is no basis in law for the two Supreme Court judges to be restrained from participating in the petition probe. And specifically on Justice Samuel Adibu Asiedu, the Attorney General says he did not participate in the injunction hearing and can therefore not be precluded. On Justice Gabriel Scott Poamang, the Attorney General argues his participation in cases but before the court by one of the petitioners cannot constitute evidence of bias. The AG further states that members of the committee have taken the necessary oath of office contrary to claims by the suspended Chief Justice. Now, the Attorney General concludes that a case of injunction has not been made out, and that the responses that the Office of the Attorney General has given to the concerns raised by the Chief Justice herself, who, has in the last few days been quite active in trying to, save what is left of her image following recent developments about her suspension as Chief Justice. Let's engage the thoughts and get some legal understanding on this. Martin Kpebu is a private legal practitioner. Mr. Kpebu, good evening. Thank you for joining us.
Yeah, good evening. Good.
Right, to start with, the Chief Justice in her affidavit is alleging violation of her rights and makes reference to body searches and not being allowed access to her phones and other gadgets. She also talks about the venue being intimidating. Are these justified grounds for complaint, and are her rights being violated, you believe?
Okay, this is Marina, right?
This is Martin.
Hey, boy, it looks like a name. I can't recognize your voice anymore. All right. Okay, so Martin, what I see is that we can't give an objective answer to these allegations yet. What I just discussed, the reason is that these allegations the Chief Justice has made, I don't think that's what the Attorney General responded to. Yes. So you see that from what I see, what the Attorney General filed was filed on 26th. That's yesterday. Okay. and I see 3 something p.m.
Yeah.
Then the Chief Justice own too, I see about the same time. It's quite close, and also on the 26th. So what happens in practice is that it is not possible for the Chief Justice to file and the Attorney General to immediately respond the way they are close to each other. I wouldn't even be surprised that if I were to look at the time again, I may find that the Attorney General filed earlier than the Chief Justice. So the short answer is that the Attorney General is yet to respond to those allegations. The Attorney General is yet to respond. So when the Attorney General responds, that one will also be called a supplementary affidavit. But maybe, if you like, let me even take the phone from my ear and then double check. You see that the Attorney General's response. Okay, if you have yours there, you can look at the top.
Okay.
You see that the Attorney General's one is an affidavit in opposition. It's affidavit in opposition. Okay? So that's the first response to what the Chief Justice filed. But that's the earlier thing that the Chief Justice filed on 21st of May, right? But when you go to the Chief Justice one, you see that it says supplementary affidavit. Supplementary affidavit. That means it's an additional one to what she filed earlier. So the Attorney General is yet to respond to what she has just filed. So let's hold our horses. Our law requires that we don't give answers when we don't have all the facts. Yes, she's made all these allegations. Yes, well, for now, it appears she has a right to complain, right? So let's hold our horses. It will be out of place for anybody to start condemning her when we haven't seen the responses of the Attorney General. That's what I would say. I'll strongly urge that we don't condemn anything until we see the responses of the Attorney General.
All right. So maybe based on what we know of her supplementary affidavit, where she talks about not being allowed access to her gadgets and stuff, just the specifics she's mentioned about the fact that she had to be searched before entrance. Her gadgets have been withheld from her, whilst those that her accusers or lawyers of her accusers had access to theirs, and that they didn't allow her family members in the hearing room. These, according to her, are frustrating and intimidating her. On the face of it, while we even await the responses of the Attorney General, are these grounds on which you believe she should be the issue should be reconsidered, maybe change of venue, for instance?
Good. So, yes, like I said earlier on, this is the first time that we are getting a lot more insights as to how this particular committee is working. I think we are getting more insights into this particular committee's work than we got during the Charlotte Say one. So it appears that, like I'm saying, it's early days. Yes, I don't want to run ahead of myself. NTV3 and 3FM, we are noted for objectivity. So if we run ahead of ourselves and I say something that, the Attorney General's response would subsequently show that the opinion I've given is not right, we would suffer a public backlash. So we'll wait. Yes, we're not jumping, but by way of education, I'm not saying Ghana we should copy, but I'm just showing you how sometimes the rules are changed depending on what is at stake.
Right.
But what I'm about to say, I'm not saying Ghana should copy it at all. Look, in the UK, there is this system when it comes to issues bordering on national security. They have this court system where, they accuse, right? Let me call the person they accuse. One, is not allowed to enter the premises where his case is being determined. The accused won't enter. He doesn't get to see what is going on in there. Rather, there's a special lawyer where he's told that tell the lawyer everything you know. So the lawyer is giving access to the charges, the information, then he relates to the accused. The accused doesn't get, and when I use accused and they are home, they will say defendant. But the key thing I'm saying is that person who stands charged, that person who stands to suffer the consequence, he doesn't enter that room, depending on what is at stake as national security. English lawyers are complaining, but the last time I knew, they've not yet scrapped it. So what I'm just saying is that sometimes some of these restrictions may happen. I'm not talking about the Chief Justice matter, this part, that's not one, but I'm just giving education.
Right.
So that's why I'm saying let's wait a bit. But in the UK, where they have been practicing law for centuries, they are centuries ahead of us when it comes to a modern criminal justice system. This system still prevails there. I'm not saying Ghana we should copy. We will not even allow such a thing here. But I'm just telling you that sometimes there are some exigencies that may cause certain conditions to be made. And let me even further add, apart from the person who stands accused not getting the opportunity to enter that room and to see the people who are accusing him, blah, blah, blah. If that person has Martin Esi as his lawyer, and Martin Esi doesn't have national security clearance, that's among the lawyers in the UK, there are certain lawyers who have national security clearance. So if Martin Esi doesn't have national security clearance, then he has to also go and look for another lawyer, maybe Okansi, who has national security clearance, for Okansi to now do the case. So it means that accused is forced to have two lawyers. And obviously that will involve more fees because you already have your lawyer you are comfortable with. But they say, no, this lawyer doesn't have national security clearance. He will not enter that courtroom. And so you go and find another lawyer who has a clearance, and he enters. Right, so I'm giving education. So let's be patient.
Okay.
When the Attorney General response, then we'll see.
All right, Counsel, thank you so much for this education and clarity you bring to the issue. Grateful for your time. You had the thoughts of private legal practitioner Martin Pebu, who has been giving more or less an education on where the situation stands now regarding the back and forth between the suspended Chief Justice, Madam Gertrude Torkonoo, and a supposed response that we are told came from the Office of the Attorney General. So we'll certainly try and get the clarity as regards whether or not these responses from the Office of the Attorney General are directly to that of Madam Gertrude Torkonoo. And also, you have been following these recent developments with the filing of a supplementary affidavit by the Chief Justice. What are your thoughts on how this matter has been going so far? Mind you, tomorrow, the 28th of May, is when the hearing will start proper. So a lot is happening, and would be happy to also hear what you make of it in the coming days. And just by way of information, just raising some of the key issues that the Chief Justice touched on. She says, amongst other things, that she and her lawyers were barred or denied the use of their mobile phones and laptops during the hearing, while petitioners or those that brought the case against her had their access granted to use their laptops and phones. So she says that move is deliberately discriminatory. Those are her specific words, deliberately discriminatory. Again, she raises the concern of the fact that she had to be searched. A body search was conducted on her, and beyond that, her family were denied access to the room. Says that her husband and children were refused entry to the hearing room. So that in itself for her is also another violation of her rights and that of her immediate family, because according to the report, she would need support or family support in the room. So this denial in itself amounts to that. She also touched on the fact that the use of the specific venue, that is the Osu Castle, as a high security zone for the hearing was intimidating. The choice of word she uses is intimidating. Says that the choice of location is intimidating, whereas per Article 146, proceedings were hitherto conducted at the courts complex. So she says the decision to choose this particular location, which is the Osu Castle, in itself was part of the deliberate ploy to intimidate her. So she has raised a question also about the venue. And then another issue she touched on is the procedural irregularity. It says that the petitioners were allowed to avoid testifying. Those that brought the case against her were allowed not to testify in person and rather relied on witnesses to do the testifying for them. And she says that's a departure from standard inquiry rules requiring cross-examination or regarding cross-examination under oath. So clearly the Chief Justice, suspended Chief Justice, has a number of questions and is seeking answers to them. So subsequently, when we do get further information regarding that, we'll bring it to you.
My Lord Justice Akabuafo.
Okay.
In a recent Court of Appeal decision, where a young man was convicted, spent some years in prison, only for the matter to come to the Court of Appeal, and it turned out that, look, there was no evidence linking the guy to the crime. But this guy had been convicted and spent. So, my Lord Akabuafo took time to elaborate what prosecutors and investigators should do so that they don't put innocent people in prison. Because sometimes by the time the appeal is heard, the person would have lost everything he's worked for in life. We don't want that kind of scenario or situation again. And that is why I strongly believe, it doesn't matter who you, the Attorney General, is. If you are not following the rules, because you see, I always say this, and anytime I met police officers in court, you know what I usually tell them? I say, look, in my almost 12 years of practice, I've represented a lot of police officers. So you, a police officer, tomorrow, God forbid, you can be the subject matter of criminal investigation. Yeah. It had happened. I've represented police officers in court. You understand? So I always tell them that, look, deal with fellow countrymen with a certain human face, so that tomorrow, if the same rules apply to you, you will not be found wanted. The same thing applies to prosecutors. Let us all be fair in our dealings with fellow countrymen. That's all that I say. As for the rest of the petition, I think I've seen Richard Jakba. He appears not to be happy with the petition to the General Legal Council.
Why is that?
Because on his Facebook page, I saw him raise serious issues that he believes that he has his own plan for this matter, and that he believes that the petitioner is quote unquote becoming a busybody.
Oh, but this one is a civil one. It's without prejudice, even civil. It's without prejudice to any criminal action.
No, he's not even talking about. I don't know what his plans are, but if you look at his Facebook comment, you can see that he's not pleased with whoever it is that is before the General Legal Council, because it appears he himself wants to be the one to petition as far as this matter
so this
is concerned.
Is more like preempting his plans.
And I think he has some reasonable suspicion that no, it may be a sinister, so that if the matter goes either way, maybe Godfred may end up, escaping from the what is required by law, because he definitely appears not to be happy with this whole thing.
Okay, so can say so finally, yes. So you see, it's based on these very damning statements, right? A serious indictment on the justice system, that you find the decision by Chief Justice Torkonoo to engage Godfred Dame not appropriate. I mean, that one we have to be very clear.
Why is that?
A man, we've just recounted all the things, so I don't need to repeat. A man who has said all these things, a man who seeks to undermine the justice system, then a suspended Chief Justice goes to engage him. I mean, what kind of country is this?
But it's well within
Dame
her
the
right
only
to
lawyer
do
in this country.
It's well within her right to do
Oh,
that.
no, it's not every right.
She decided that this is the lawyer she wants.
It's not every right that you exercise. It's not every right that you exercise. Sometimes you look at the public interest and then you forgo certain rights. It's not every right. What's the thing? Those of the Bible. I think the last time I quoted the matter of 1 Corinthians 6, right? That area onwards, where they say, the Bible says, everything is permissible. Everything is permissible, but not everything is beneficial.
That's morality. That's morality.
Okay, today you can say that's morality. Why go to morality. Find out tomorrow? Yes, even granted. Why are the churches full? Because people ascribe to a certain religious code. So you haven't shut down my argument when you say it's morality. A society without morals, what would it be?
You know, when it comes to law, I mean, a legal right, it is a legal right that she exercised. And I mean, nothing can clog that right of hers.
Look, even to become a judge, he stated that you are talking about morality.
And he stated that moral turpitude. So you see,
it's not everything that's only about crime specific.
But
to be appointed
going for a lawyer is an exercise of discretion. Whether you want to go with quarters A or quarters B, irrespective of the public opinion.
But the matter of optics is key, is it not? I mean, you cannot also discount that. I mean, based on everything that has been said right now, which you also acknowledge that the General Legal Counsel has reason or should be also looking into the said conduct of Godfrey Yeboah. I mean, you said that in your earlier submission. Based on that,
yes.
And then now he is a lawyer to none other than the suspended Chief Justice. It doesn't concern you based on the optical analysis of things, from the optics.
Yes, like I said, it is a discretion, and it still remains her choice. Now, if at a point in time she decides to terminate the legal relationship that she has with him, so be it. But to cover it up or to conjecture in the way of the optics alone will not sit well, because aside she being a learned justice, she has all the faculties to reason through why she would choose a particular person, irrespective of what a certain or let me say, irrespective of what a number of persons think of her choice. You could go for, just as a private person, you could decide to go for a particular lawyer, and one would say, but why have you gone in for this lawyer? And I mean, in my almost decade of a practice, I have seen persons who have had such rhetorics, but the question is, it's choice. Someone would want to go for a lawyer who probably drives a certain vehicle. Someone would want to go for a lawyer who sits in a trotro. At the end of the day, the person is looking at the quality of service or a certain relationship that has existed over the years. So there are myriad of decisions that goes through the mind of an individual in selecting a particular lawyer, and that cannot be discounted. It is a legitimate right to go in for anybody, including Godfrey Dami, irrespective of the optics and the analysis.
So, Godfrey Dami himself has been responding to this argument of he representing Gertrude Torkonoo, her leadership, and he says that position of the optics is baseless and completely unfounded, because his involvement goes beyond Justice Torkonoo as an individual, and also the fact that it's about challenging the unconstitutional manner in which he says this petition process has been handled. That's what he said. I just want to put it on.
Before my senior Martin comes in, let's look at these two scenarios. So Godfrey is lawyer for Vincent Assefuah. So they first brought an application. In Relief 1, they say that Her Ladyship, the Chief Justice, was not notified prior to the president sending or consulting the Council of State. That's the claim. Now, the claim of not being notified requires personal knowledge. Yeah. So once that issue came up, some of us said, on what basis did Vincent Assefuah get this privileged information that the president has not consulted her ladyship, the Chief Justice? So then it created an impression of some communication between the plaintiff and her ladyship, the Chief Justice. Not long, there was a letter now from the Chief Justice herself asking the president to furnish her a copy of the letter so she can, as it were, put in a response. So already right from the beginning, the impression has already been created by way of conduct that there's some kind of communication between lawyers for Vincent Assefuah himself, and now suspended Chief Justice. Now that matter goes in and it fails. Only for her ladyship, the Chief Justice, now suspended, to formally come before the court. Now gets represented by the same lawyer for Vincent Assefuah. And like you pointed out, it's about the optics. Me, where I sit here, that I will not say that food should be taken from the mouth of a colleague lawyer. No, this is what we do for living. And so now that he's back into private practice, he needs to make a living. I will not say who should be his client or who should not. But you see, we are working out the optics. Look, the head of the judiciary, right, gets represented by the immediate Attorney General. At the time when there have been serious questions about, the public, the verdict is out there in the public. That no, you have not acted between the two political parties. You have taken side. And for that matter, like Caesar's wife, you must live above reproach. You understand? Caesar's wife must not be somebody whose name is associated with anything below the, like people can gossip about or run rumor about Caesar's wife. No. So when the story came that Cleopatra had something to do with Mark Antony, it was as good as you are God. As the wife of Caesar. That is how, when you get elevated to a certain position, you cannot do what a DG can do. Me, I don't want to be a judge. So I am in my corner. You understand? Now, those who say they want to be a judge, there's a certain elevated conversation about them. So once you become Caesar's wife, there is a certain benchmark around you based on your conduct. I would have wished, and this is possibly wishful thinking, there are many, many senior lawyers in this country, right? Many, many senior lawyers. Now, if you have a situation where serious allegations of this nature, the minority in parliament have entered, the NPP itself had actually had a demonstration relative to this. Then not only that, you have a situation where the immediate Attorney General is your lawyer. Have you found out who is representing her before the committee? Have you found out?
Yeah, some people raised it, but we didn't get answers.
No, assuming you have my learned senior Ayiko being her lawyer before the committee, what would be your view?
Well, it'll be different.
Do you get it? So I think strategically, I don't have the capacity to advise. No, I don't have the capacity at all.
Yes, but you have an opinion.
But you see, there's a reason why you read that Bible, the verse. The account, if you put in account, you are doing now who and yet adie nyina so na fata. Do you get it? You adie nyina ho kwan. But and yet ni nyina dey fata. There's a reason for that profound statement in the good book. You know, her ladyship, the Chief Justice, is a lay preacher at ICGC. I want to believe that going forward, maybe some of these things will guide how this thing is approached. It's for good reason. You see, it's not an ordinary person. If you look at our governance structure, after the president, the vice, Mr. Speaker, she comes next.
Article 57.
She comes next.
57.
It's not. Look, the events playing out is not a joke.
Well, for the respond to the disposition of others, that look, this matter has already been politicized, even though it's a purely constitutional matter. Who? We have allowed the politics of things to also get in there.
By who?
So I mean, the suspended Chief Justice going in for is really not outside of the politics of things playing out now in this case.
Let me tell you, I know the high hopes President John Mahama had in her leadership, the Chief Justice becoming Chief Justice. Right. I know.
Okay.
In fact, proud to she becoming the Chief Justice, President Mahama actually said, when Eniebua was just about, that he is very confident that the new Chief Justice who will come after Eniebua will restore.
The one they were taken out of context.
No, because that statement was made when Eniebua was just about exiting.
Yes.
And she was coming.
And they were saying that meant that GM said.
In fact, it was about
Yes, so, but you know they took it out of context.
It was deliberately done. They don't provide when it happened. So GM was very specific that he is so confident that with her ladyship Justice Gertrude Torkonoo becoming the Chief Justice, she'll restore, because the Afrobarometer reports and others created an impression that there was something untoward happening with the judiciary. And so JM, then opposition leader, said, look, he is confident that with her ladyship, the Chief Justice, becoming the Chief Justice, a lot will happen. Let me also state here, even at the political committee of the party, after FECNEC, one of the highest political, committee of my party, the NDC, right? When her nomination came, President Mahama indicated to the minority that there shouldn't be any opposition.
Wow.
President Mahama indicated
at the political committee level that nobody should oppose her becoming Chief Justice. So if you note, unlike the Gawu, Kumsin and Co., whose appointment came to the entire floor for a vote to be taken on them, in the case of a leadership, the NDC minority in parliament, because it was just a minority of one, and they could have unsettled everything. All they needed was to just get one person in the MPP at that time to flip, and that should have lost whatever. But you notice that when it came to her appointment, from the committee level, it was unanimous. Her approval was by bipartisan consensus. Then on the floor, it was unanimously approved. That was the confidence President Mahama personally had in this Chief Justice. That is the level of confidence he had. Why? The grounds in the petition, unless President Mahama is a soothsayer or by way of clairvoyance, how was he going to see that the Chief Justice will conduct herself in that manner? I mean, how? It is just not possible that President Mahama could see into the future. Assuming that they claim that, she paid a per diem or so and so for the husband, or as I speak, I've decided I don't want to bother myself with the grounds. Assuming these are the real grounds for which reason these decisions are being taken, guess what? How could President Mahama see into the future to say that her ladyship, the Chief Justice, was going to conduct herself in a particular manner. How was that going to be possible, Alfred? And so, right from the onset, there couldn't have been any issue of politicization until the NPP, busybody, decided to drag themselves into this impeachment conversation. With the press conferences, not only that, they even went as far as organizing a demonstration. Didn't they do it?
Yeah.
Look, when I listened to Godfrey Adame on one of the radio stations, makes the point that the lawyers for the petitioners are known NDC lawyers. So, wow. Wow. Yes, you can say, and without any equivocation, that Malene Senior, Mr. Chachuchigata, is a proud member of my party, and he associates with that. But how in God's name do you say Tadio Sorry is an NDC member? Look, I'll tell you this. When I became, in 2008, one of the campaign promises President Mills gave was to find the killers of Issa Mobila, the Northern Regional CPP chairman. You saw the circumstance under which he died. The soldiers, his legs up, tied him up until he died. So it was one of the NDC campaign message in 2008. Well, when we came to power in 2009, President Mills then decided, may his soul rest in peace, to prosecute the people, the perpetrators of that murder. Guess who their lawyer for the accused person was? Mr. Tadio Sorry.
Yeah.
Okay.
The NDC lawyer is the one representing Mr. Sorry, and he made a point that even in Ghana at 50, at that time, my Lord Justice Kulendi was the lawyer for the Ghana at 50 people. He said he assisted them.
Yes.
And many other matters that he's done, including representing Obiamwa.
That's it.
Guess what? Because his people master was Ambrose Derry, the two of them did Malam Issa's case. Malam Issa's case. Yeah, so he is just a lawyer who, once you approach him for legal representation, he is willing and able to. Like you pointed out.
Some will even tell you, if you know Sorry's family, they'll tell you that he's more of MPP in terms of family, the family structure.
This man, what's the name? My own brother, Oliver. The things Oliver says about JM or the NDC government, sometimes I wish I can call him and say, my brother Godwin, what's happening? But that's a free-minded Ghanaian. So to suggest that the petitioners are being represented by NDC lawyers, it's mischievous and deliberate to poison the atmosphere. Now that it has come out that you are the lawyer for the CJ, now suspended, what's your response to that? Then you are all over the place. That, if it's so, then we are guilty by association. It cannot be. At least, let us handle these matters in good conscience. I'm surprised that Godfrey says good men should rise up. Today, if good men rise up today, you will lose his license.
Yes.
On what basis?
But the tape is clear. And this one, they call it no further inquiry. This type of tape.
One of the,
when you hear it,
it's not conclusive.
It's called no further inquiry. Ask the people who let this law in America. They'll tell you this one is called no further inquiry. It's too clear. The main thing is that
if today, with respect, good men rise up, as Godfrey is calling good men to rise up, you lose his license.
Yes. Absolutely.
One of the reliefs.
But I had a question, so I was going to answer. So I'll be very brief. Yeah, you pose the question to me and then yes.
Because on.
So my answer, you said Governor Dame said that you know.
No, it says that argument of the optics is baseless essentially.
Yes.
And without merit.
So the word baseless.
And he references what Edujit talked about. That you have some of the petitioners also being represented by persons known affiliates of the NDC. So really, what's the point? And then also the fact that this matter has been politicized already, so he getting into it doesn't hurt the optics as it's at play already.
Okay. Yes, okay. So even before I go on to the substantive question, please let's note the issue of when Ma'am was saying is just a moral matter. Please, Article 128 Clause 4 says that a person shall not be qualified for appointment as a justice of the Supreme Court unless he is of high moral character and proving integrity, blah, blah, blah. So the point I want citizens to note is that we've not divorced morality from the law. The two are interwoven, inextricably interwoven.
So when you hear, a judge say that what is legally right cannot be necessarily morally right and vice versa. It is not.
He has totally misconstrued me.
Okay.
No, because before we move on, just a minute.
Quickly.
The point is that qualification to the bench, moral turpitude is part.
Okay.
Now, in the exercise of one's rights, it has nothing to do with morality. It has everything to do with the legal rights exercisable. And when that person is exercising his legal rights, what does morality come in?
So you let's leave it. Me, I just wanted to show you that in the law.
Viewers watching morality in jurisprudence by Professor Austin, it has been clear. Jurisprudence has engaged and exhausted the issues about law and morality. And it has worked from John Austin, John Bentham, Jeremy Bentham, all the way to Kelson. So issues about morality, I'm very well placed in it and understand how it is interwoven and divorced in the law. But when it comes to exercise of legal rights in getting a lawyer, it has nothing to do with morality. Because when one is going on to ascending to the bench, moral turpitude is one, because as a judge or ascending to that high office, it must be ascertained whether or not you qualify for that position. So your moral issues will be part of the conversation, but not what I am saying. It's more like putting...
Okay, can I go? I think you've made a point over. I just wanted to viewers to know that, look, in our law, and it's not only in Ghana, many places across the world, there is that confluence. Yes, that point is made. As to whether you think it doesn't apply here, that's your opinion. It's fine. Okay. Yes, so now, Governor Dami, the word baseless. Yes, that's what I want to address in a minute. I mean, in view of all the facts we've referred to so far, okay, let me recount briefly. The trial judge telling Godfrey Dami, stay away from this trial. Godfrey Dami ignoring her. The things Godfrey Dami has said in the tape, right? Number 3, Godfrey Dami adding ACP Agojo to the treason trial when he himself said there was no evidence against him. Godfrey Dami covering up the second Cecilia Dapa scandal. I'm not surprised he would say that is baseless. The claims are baseless, meaning that he himself, his judgment has always been suspect. Let's repeat what I'm saying. He's saying that the charges against him are baseless. You understand? I'm saying the word.
He says that argument of
optics. That's what I'm saying.
Charge.
Yes, I'm calling it's called the argument of the optics. It's a charge. People are charging him that the optics look bad. And Godfrey Dami is telling us that that argument that the optics are bad for him is baseless. And I'm also making the argument that for a man of his track record, and I've named all the things, right? When he says this is baseless, I'm not surprised, because from his own track record, all the things we said, his judgment has always been suspect.
There's one of the demands, the reliefs that the Chief Justice is asking for in this particular interlocutory injunction. And that's going to be, we'll deal with it. We'll deal with the details. In fact, there are about 16 of them, but there are 3 of them that we'll zero in. And because I'm mindful of the time for one of our guests, one particular one, let's start from the second one. The second one, we're going to put on the screen, right? So I said a declaration that upon a true and proper interpretation of the same articles, the right of a Chief Justice to a public hearing and all the incidents of a fair hearing may only be excluded in the interest of public morality, public safety, or public order. So
again, that's as in many places in our constitution, morality you will find.
But this one, this third one, that a declaration that under the same article, a Chief Justice who is called upon to participate in a hearing conducted by a committee constituted under Article 1466 to inquire into the merits of a petition seeking the removal from office of the Chief Justice can waive the privilege of in-camera proceedings. Is it her right to do so? Counsel, quickly. Okay. Is it one that you support?
Let's separate. Straight answer is that her waiving of her right would not automatically result in a public hearing. That's the straight answer. Because when you look at the phraseology in Article 146, I think it's clause 8, it doesn't appear that...
8.
Yeah, 1468. But did I mention a different?
No.
Okay. Yeah. So it doesn't appear that it's meant to protect her alone. No, let's read it. This is what it says. It says, all proceedings under this article shall be held in camera, and the justice or chairman against whom the petition is made is entitled to be heard in his defense by himself or by a lawyer, blah, blah, blah. Yeah, so from the way it's been phrased, it's not clear that it's only to protect the accused in a way. When I say accused, so that we can, effective communication. It's not a criminal trial, but for a lot of people.
You are using it in the loose sense.
Yeah, in the loose sense, so that we can communicate effectively. We don't gain anything by using big words when we can. Yes. I'll use accused freely. Yes, I'll use accused freely because
this bit.
If in certain jurisdictions, so you see that even in a criminal case, they don't use the word accused. They use the word defendant, whether it's a criminal case or a civil case, right? All right. So looking at it, you can see, and I've expressed an opinion on that. I also agree that the proceedings should be telecast live.
The hearing of this 5-member committee.
Yes.
And the petition.
Yes.
You support the call that it should be telecast live.
Live.
Even though the constitution is explicit that it should be in camera.
Yes. So right now what we are saddled with is the language of the constitution. And I don't have the last word on it. So my opinion that it should be telecast live, please, it's not, what do you call it, the meaning of the constitutional provision. It's my personal opinion. As I've told you, my reading of it, it doesn't appear that it's only meant to protect the accused person in this case, but rather it appears it's for the whole of the system. There is still, though reduced, myth around the justice system, judges, the wigs, the gowns, and generally, our society is still evolving, so we accord a lot of, extra high value to the justice system and all that. So you can see that on matters concerning judges, we want to be sure that things don't come out in a manner as would make the public lose confidence in the justice system, etc. So you see that based on this history, etc., it doesn't appear that it's only meant to protect the person who has been accused, but it's also meant to protect and especially maintain the confidence that the society has in the judiciary. And it's not only the judiciary. You see that this provision 146 also applies to a number of the independent constitutional bodies. I think immediately I can remember the electoral commissioner. Yes, we are going to remove the electoral commissioner.
The auditor general. All of those.
Yes.
People,
so you see that.
Yes. All of them are subject to this.
Very good. You say it. So, and the independent constitutional bodies, there are at least about 7 of them in the constitution, right? So you see that this provision is meant, we're looking at those days, 1992, the way our society was, we're not that much enlightened. Even today, yeah, we are still far behind, right? But at least we've made substantial progress. So in matters like that, even if you want to test how sometimes people can get angry, you remember, okay, let me not cite the example, we've moved on. But generally, you can see that this constitution was written more than 30 years ago. The society at the time was what this constitution reflected. But now we as a people, we've moved on. Yes, we've moved on. The train has left. So the constitution now has to play catch up. That much is very clear. This constitution itself has been very clear that it's no longer fit for purpose. The design, everything is no longer fit for purpose. So thank God President Mahama has set up the committee. You know, for 8 years, Akufo Addo would have none of it. You know, that's why JM would always stand tall above Akufo Addo. I'm like, come on, a lawyer, 8 years, tweak this constitution for us. No, he wanted all the power, all the trappings of power. Yes, so moving on, yes, my heart is with the call for a public broadcast, public telecast of the proceedings. But when you look at the text of the constitution, it's difficult. So maybe somebody should go to the Supreme Court, though it's difficult, you never know. You never know. Because, so I was saying something extra, that how about us looking for more innovative ways to make the argument? So number one, can Musa Dankwa conduct a poll on this matter again? So that we are looking for other arguments. If we conduct a poll and you see that over 60% of the population say we should do it live, that will add to the calls for the system to do something.
And you balance it out with that concern that you yourself underscored, that this in-camera provision was not born out of oblivion. There was a reason why.
Yes.
To, for instance, protect the identity and also the sanctity of the entire process.
Excellent. Yes.
So if that's the case, even if the public is making that demand, would the public demand surpass the intent?
It appears so.
Of the provisions of the Constitution?
Yes, it appears
so. The framers of the Constitution.
It appears so. That was the argument I made, that as a society we've moved ahead of the Constitution. Yeah. Yes, the transparency, the calls for transparency have grown louder than this constitutional provision. The society has clearly moved on. So where you have society move, and that's one other area where you see issues of morality coming in. Sometimes society advances ahead of the laws, and so the law have to be amended to be able to catch up. This is one clear case where you see society has moved on. That no, listen, and that's how come you see the petitions leaked. The petitions leaked. People have read. We will not discuss here, but people have read and have made judgment. So we should stop playing the ostrich. Rather, want to see how cross-examination can demolish the things we've read in the petitions. You see it. So that's how come there is a higher call to see the proceedings, because you're like, we've read on paper X, Y, Z. Of course, we will not mention the details. So, what kind of cross-examination is going to undo these things that we have seen in black and white? So let's do that thing. So Musa Dankwa should do a poll on this question. Number 3, we can also look at maybe demonstrations in favor of a public broadcast. Yeah, when the society makes a lot of agitations, asking for something, because justice emanates from the people in Article 125. So if people say that, look, our sense of justice today is that this thing must be made public, and after all, even the Chief Justice has also waded in, it will add. So we are adding all the arguments. Let's read briefly. It says that Article 125, Clause 1, it says, justice emanates from the people and shall be administered in the name of the Republic by the judiciary, which shall be independent and subject only to this Constitution. Then you see 1252 talks about this participation of citizens in the justice system. So you see the assessor system and then the jury system. So the argument I'm making is that to the extent that it appears the majority of the people think that the justice in this case requires that it should be publicly broadcast, I think we should look at it well. Then, you see, this one is called shaking the kaleidoscope. Shake it, keep shaking. You don't know what you get.
Thanks for watching. Like and share the video. You can also drop your comment. Please don't forget to subscribe. Click on the bell to turn on the notification.